I'm Matthew Kurbis, the subscription attorney, and this is Law Subscribed, your dedicated source for all things subscriptions and the law. Thank you to my sponsors. See links to them in the show notes. Everything discussed is only for educational and entertainment purposes. Enjoy the show. I'm thrilled to have with me today fellow Geek in Review guest alum, Conrad Everhart of Flatiron Law Group. Conrad, welcome to the podcast, Law Subscribed.
Hey, Matthew, nice to be here.
Well, folks should definitely go check out your episode with the Geek in Review, but just in case they haven't listened to that before hearing you here, give us a little intro about yourself, Conrad. Who are you and what is Flatiron Law Group?
Well, unfortunately, at this point, a senior lawyer. I've been practicing for over 30 years. I was a BigLaw associate and partner for a couple of decades, Jones Day, Bryan, different places. And I was in the private sector for a while. I was a general counsel of a solar company. But when I came back to practice, I hooked up with some of my other BigLaw refugees, and we created Flatiron. And we'll talk about Flatiron, but Flatiron is a disruptive flat fee firm that does premium deal work, mostly M&A, but other things as well. And we do it, by leveraging our own tech and other things we've invented. And, we like to think of ourselves as a pretty far out place.
Yeah, I think so too, which is why I wanted to have you on the show. I think it's reasonable to assume that when you were in BigLaw, you were billing time, and then when you went in-house, you were not billing time. You want to talk a little bit about what that was like, having that transition?
Well, look, there's a community of us that have been thinking about a different model for a long time.
Mm-hmm.
But when you're within the big law firms, they're like ocean liners. It's difficult to move the model. The model was in some ways accidental. They bumped into it as hourly billing. It wasn't that way historically. And so for decades, literally decades now, as well, from the beginning of the internet, even before that, I've been thinking about, ways to deliver legal product in a different way where you could preserve the margin, but be more efficient and be more competitive on pricing. And needless to say, I was banging my head against the wall and BigLaw, and there was and the ability to accomplish that and change the culture in BigLaw. I mean, I'm running out of years to be able to do that. Not that it's not going to happen in BigLaw, but like everything else in life, it's a lot easier to implement change from the outside.
Mm-hmm.
So, we had an opportunity to get outside the firewall, we like to say, because of accidental circumstance. We had all gone to the private sector. It was hard to get back into the BigLaw. The economics weren't great because we had been detached from our books of business. We all knew each other. We all had different visions of how to impact the model. And cut me off if I start stream consciousness here, but I mean, there were a couple of factors that made the idea of a disruptive law firm more viable in 2017, 2018 than they did in 2007. One of them was the acceptance of the virtual law model and of, I was at VLP for a couple of years, virtual law group, and like Ryman and Fisher Broyle. So I'd gotten my feet wet with the virtual law firms, the acceptance of the virtual law firm, the acceptance of the internet as a commercial platform. So that's one thing that was, that was one. The access to labor, the BigLaw has this, for guys my age, remember the movie Logan's Run thing going, a model where they train and they get these kids all trained up for 10 years and they get rid of them. And they replace them with young and experienced labor, which they can then resell at a profit. And unless you show a propensity for bringing in business, or you're some kind of whiz kid in some niche practice area, or unless the economy is really booming, in which case they put you in a different kind of career path. Once you reach that 10-year path, you're out in the streets. So you try to go in-house, and some of them do, but then you wind up, being on the roster of a Axiom or Bliss as an outsourced lawyer. So I have this wonderful talent pool that I can reach to, which I can pull in, and I'm really on a contractor basis. I don't have to put them on my balance sheet. I don't have to train them. So I have the commerce part, I have the labor part. And the other thing that was the game changer for us was the access to cheap computing power. Now suddenly ASW, Google, I can get real heavy computing power on the cheap, on by the drink. And I have access to all these cool tools. I mean, you should have my partner Lenny in it one day. He talks about there's so many tools out there that are not legal tech tools that you can leverage, and we could talk about some of the technology we created. We based it on Airtable and Power Automate, all these fairly modest platforms, allows us to skip jump over generations of technology investment that the big law firms are doing. It's kind of like, being in Africa and they jump from 1G to no G to 4G because there's nothing. We can jump, multiple generations. Those things combined gave us suddenly what was always theoretical, and it made it real. We could actually do it. We didn't need that much money to invest in technology. We didn't have to hire all this labor. I just had it already. And clients were accepting the virtual model. So it all fell into place for us.
So that name Flatiron sounds to me like it has multiple meanings, in particular the flat part. Do you want to talk about the origin of that?
That was purely coincidental. We called ourselves Flatiron because we're still based on the WeWork and on a Penn Station there. So we're in the Flatiron district.
Okay.
And historically, Flatiron's been associated with the startup community in New York. So we liked that. We thought it was cool. Nobody else was using it. So we used it. Now, happily, a happy coincidence is that we're doing things on a flat fee, but that was just a happy coincidence.
Okay. So then let's talk about the fee. And I will say you have on your website, which is flatiron.legal/r-pricing-model for folks who want to go there and look at this while they're listening to the pod.
That's about to be replaced momentarily, but there's still a pricing page. Don't worry.
Sure. Somewhere at some point, whenever this goes live, because I do record these some weeks in advance, there's some pricing information. And while you don't state exactly what the prices are, because it seems like it depends on the deal kind of a situation, you do commit to this fixed fee per deal or buckets of deal pricing. So I'm curious. Also, my listeners are curious to know, how you came to that exact model. Now, of course, we don't just have subscription-based law firms on the show. We have anyone who's ditched the billable hour, but curious about how you're doing that, how much you've been able to actually distance yourself from the billable hour if you're still doing shadow bills or checking time in certain situations. So, my listeners are really interested on the fees of it all and how you've structured that, lessons you've learned, that kind of thing.
Well, we got to go back to the origin story then. So
let's do it.
We created Flatiron back in, I guess, 17 or whatever. It wasn't even called Flatiron then. But the idea was that we were going to be disruptive and we were going to challenge the model. We didn't know exactly what that meant. But we started experimenting with fixed fees. We were doing M&A work. And we like M&A because it's so incredibly inefficient. You go to venture or tech commercialization, a little bit more commodification of those areas. But that M&A is just grossly inefficient the way the big law runs it. In particular, because the way they handle due diligence, which became now a pairing card for us. So when we decided to start experimenting with fixed fees, which we were just doing, in the dark at the beginning, it really forced us to rethink everything about the way we deliver legal service, because we were no longer making money marking up junior labor. So the labor is now a cost, not, it's a utility. It's no longer a profit center. So I'm now like you, I have to make money and margin by being efficient. So the idea was, how can I deliver the product more efficiently at the same level or even a higher level of quality so I can compete with big law, but how can I deliver it, more efficiently by using a different process? And that's where we came up with, this what is now really three tiers over the years. One tier is an obvious one. It's just like Ryman and VLP. We have a light overhead footprint, where we work in Penn Station, and we work virtually in a distributed way. We have people all over the country, but they're working from home mostly. We have a practice platform that's all online. So and I learned a lot from VLP. So that's, but we're very different from those firms, if you want to talk about that later. But I did this. So one thing we did was the over. Second thing, we already talked about labor. We employ, for lack of any better word, a general contractor model. I mean, we have some equity partners, we have some counsel folks that are at the top level, but mostly, we're contracting out with senior associates for our labor, and with experts. So for tax, for HR, for CFIS, or for whatever discipline that's not in-house, we have a long relationships with other firms. We bring them in when we need them, only as long as we need them. They'll sit in our balance sheets. And the same reason why a general contractor model is used for building a house. It allows us.
I do have a question on that, though, in particular on the labor side of things. And hearing you say this again reminds me of your interview on the Geek and Review. So I'm curious to know from a business perspective how you're managing the cost of those contractors, because if you're doing a fixed fee, do they get a percentage of the fixed fee? Are they charging you hourly now, so you still have some hours to manage?
Yeah, we do. They mostly that we can. Sometimes we split profits with them, which with the ones who have been with us for a long time.
Yeah.
But often we do it by the hour. But we're paying them $150, $200 an hour. So they give me 100 hours, it's $20,000, 200. So after over the years, we've gotten pretty good at figuring out how many hours that they're going to spend on things. So yeah, there's still an hour component. We pay them by the hour, that we pay them a lot less than we would be paying if we were at BigLaw.
Sure. And I mean, because for me, I'm thinking everything you just talked about the efficiencies and doing that, the moment you tell them, because you just said, it's if it's 100 hours, you know what it's going to cost. You could give them a number, and now they have to efficiently do the turnaround for you.
Yeah, I can do that, and I do that sometimes. In fact, we're talking right now about doing that with one of our guys, and we do that sometimes. We'll say, 25,000, 30,000, 20,000. You do this is what you do. And the way we work is we'll pay them a little bit more if they take risk with us. Broken deal risk, the big risk in M&A, right, is the busted deal risk. So if they take busted deal risk with us, we pay them a little bit more. If they don't, if I have to come out of pocket, if I don't get paid, then I pay them a little bit less. But we do cut deals with them. You're right.
Yeah. And so, because I do a little bit of small transaction asset purchase agreement type M&A work in Illinois. I mean, we're talking like definitely sub $1 million transaction, and usually less than $500,000. And so what I've done, because I leverage the subscription model, is I do a subscription add-on the moment that we start that process. So, the letter of intent has been accepted, because I just do $20 a month, $50 a page for folks to get started. But if they're a business client, they're probably starting at $100 a month. So, for, $200, we get the letter of intent sorted out. And then the moment we start drafting that asset purchase agreement to close, it's another $800 a month. And so whether we close or not, I'm getting paid for the work that I'm doing. Yeah. But now granted, I'm profitable too. Like I'm virtual and all that stuff. My overhead is stupid low, but I'm potentially leaving money on the table by not doing the percentage of the deal or based on the amount at, for purchase and all that.
I've not tried the pure subscription model. Remember, I'm competing against BigLaw, and I'm not cheap. I'm cheaper than they are. They get paid at closing, basically. I mean, they get a retainer and they get some progress payments, but in M&A, you get mostly paid at closing. So if you're not getting paid at closing, that's a hard sell with the kind of money we're talking about. We price ourselves basically off a discount of BigLaw. So we're doing what I would call middle market M&A, 5 to 200 million. So it's not the biggest deals, but it's the middle market, mostly tech, not exclusively tech. So I'm opposite private equity. Typically, they're buying bootstrapped entrepreneurs, which we represent a lot, and they're paying 20, 30, 40. There's an earnout involved. The private equity fund is typically, represented by a AmLaw 50, oftentimes Magic Circle if it's outside the country, and they're charging 500,000-600,000. So I'm trying to come in about half of that. So it's a big money. We're making nice money, especially under our model, but we're taking a lot of risk because the deals break. And typically the way we work is we take a deposit, which is non-refundable. It's not a retainer. It's usually 15 to 20%. And then we roll with it until closing. Now we have escape hatches. If the deal goes too long, we can revisit. If extraordinary circumstances occur, we can revisit the price, and sometimes we do. And then we typically negotiate if there's a broken deal. And it's worked out pretty well. The last 2 years have been choppy because the M&A markets have been choppy. So we've had a lot of broken deals, which is not great. But
is that buy side, or you're representing seller then mostly?
Yeah, we're representing a lot of sell. I'd like to do more buy side, but buy side is a harder sell to get a small law firms. The interesting thing, Matthew, when we can talk about our technology, the interesting thing is that buy side likes the way we run the deals. They like the way we manage the data. They don't hire us. They still hire Kirkland and Ellis or Allen and Overy or whatever high price firm they use, but they refer their targets to us because particularly they're disorganized targets, the bootstrap targets where there's a couple of entrepreneurs that have never raised outside money and the place is a mess because they know we'll come in and organize it. So that's what, and we're trying to get more exposure on the buy side because frankly our technology works better on that side. So we're not doing subscription, we're doing fixed fee, we've done 30 whatever deals over the past 4 or 5 years, and we've gotten pretty good at knowing how to price it, and we don't always win, by the way. I get, particularly in an environment right now where there's a drought, we're coming out of the drought, but there's some starving big firms out there that will underprice me, and they're of course they're giving an estimate, not a fixed fee, but it tricks the client.
Sure.
And, and we're not small law, which is sometimes confusing to clients, where I don't compete against a small regional firm. They're charging 35,000 to waive at the papers. I can't do that. I do it right. I do the big firm drill. I cover all the disciplines, and so I have to be in a sweet spot. But Matt, what I've been able to do, Matt, is through the application of our labor model and through the application of our technology and our process and our overhead, I've been able to drive down what I call the price of the non-equity labor, right? And the equity where, that you look at just non-equity labor, the junior labor, the counsel, the experts, the tax, I've been able to drive that per deal, usually under 100,000, sometimes a lot under 100,000. So you can see if I'm pricing myself at, whatever, 40, 50% discount to BigLaw, it's a big margin there, for the equity partners. And that's how our model works.
I can't help but try to find a way that works for you with the subscription model. I like to call this subscription therapy portion of the podcast. Well, obviously on the buy.
Listen to you.
Yeah. You let me know if you think this would work or not for you. So, obviously with the buy side, one of the reasons I prefer buyers as well is now they've bought the business. Now they need fractional general counsel. And so that's a no-brainer. But I have to imagine, and I wonder if you've seen this now since you've been at least added to some version since 2017, seller sells. Now they're sitting on a pile of money, and maybe they had debts and they had some other things. That might be why, private equity's looking at them. Who knows? But maybe they want to go start their next business. Like, isn't there opportunity there, or are you really focused on the niche of we're just doing the mid-market M&A deals?
We do plenty of corporate work, and as much as startup doesn't fit into our model, we're startup guys, so we do a lot of startup work, and we do it for equity oftentimes because we're looking for more of a bang. But we do represent those guys, and by the way, all these guys that have sold their companies and have been represented by us, they are our investors in our technology now. because they all like the platform, and they're our best investor. So we spun our technology out into a sidecar, as you probably heard in the other podcast, and then we turn them into investors, and they're also continue to be clients. And these stupid M&A deals, they're like the gifts that keep on giving, because there's a purchase price adjustment, and there's an earnout 2 years later, and it just goes on.
Yeah, and something else you were describing earlier, which I think is an analogy I've heard in some places, I don't know if we've said it on the podcast yet, is if you need to have those hard conversations of change of scope because circumstances have changed, it's sort of like the construction industry. Can you imagine paying builders by the hour? You would never want to do that. They still give you a
exactly
price.
right. Yeah.
Right. They give you a price. Hey, we found that there's mold here, or we found that the foundation is actually on a bunch of clay, or it's it's a sinkhole or something. So you change the scope.
Look,
You just can't see certain things.
we changed the scope exactly. I mean,
Yeah.
we our pricing is based on closing between letter of intent and closing of 90 days. And what we'll negotiate out to 120 days sometimes. But if it goes beyond that, then our model is broken. Then you have to revisit the pricing, and that does happen. I mean, we had a circumstance a couple of years ago with a French buyer. Then they go on vacation in the summer, and they were buying a third-party maintenance software company that was takes care of hardware, and they were doing it for the Defense Department and for defense contractors. And they wanted, even though all the contracts were at will and the clients could walk away, as a proxy, they wanted us to go get the consent of the Leidoses of the world and then other defense contractors, where because if you go to their standard website contract, it says you can't sell the company without their consent, but nobody at Leidos is in a position to consent.
Right.
So we wind up spending literally months trying to find. I went to one of my old college teammates, who used to work at Leidos, trying to figure out, he can help me. And that deal wound up being delayed for 3 months. And that was the kind of circumstance where we asked for a change.
Right. I mean, if you can't confidently close with your clients in 90 days or at the long end 120 days, I mean, you've got your transition to subscription model right there. It's you divide your total price by 3 or by 4, and then hey, if we go into month 5, boom, that's the 5th month.
I'm happy to talk subscription with you, but the issue is there's a lot of risk in these deals, and the market is that the client doesn't pay until closing. So when you tell them they got to start paying as they go, then I wind up in a competitive disadvantage.
Well, I agree with that. What I'm saying is I think it's easier to, it's not quite a like true subscription model, but if you like you go into an extra month or 2 or 3, like I think it should be predictable for the client to understand, hey, each month we go over because you want us to chase some rabbit, down a hole, and that will at least keep them on target of, hey, we got to close in 90 days, otherwise becomes X amount more per month.
Lenny and I just had this conversation yesterday, and he's telling me we should ask for, he's not calling it subscription, he's calling it progress, but there should be some more skin in the game as we go through the process. And
you could call it whatever you want. I think, but I agree with Lenny.
Yeah, okay, so you can talk to Lenny. I mean, look, I think we get more bang for the buck at the end of the day if we take the risk and we act like the banker.
Yeah, I agree.
The other piece here that I want to touch on is maybe the most important piece is the platform, the technology, so we're sitting here in 2017 circa doing, suddenly there's a lot of M&A going on. We're doing these little middle market deals. I don't have the bodies to throw at the due diligence. And I assume your audience knows just how incredibly inefficient the traditional due diligence process is. You get all this unstructured data from the seller. A lot of it's disorganized and unlabeled, and you try to organize it, and then a pool of young, expensive attorneys dives into the same pool of data repeatedly at different stages of the deal, when you have to deliver the due diligence, when you have to do the rep and warranties, when you do the disclosure schedules and then integration, and at some point you prepare a memorandum of some sort which summarizes and highlights the red flag issues, and it's a incredibly inefficient process. So I'm telling Lenny, who's by trade is a technology commercialization lawyer. I'm telling him, but he is a computer programmer. He has a computer science degree, and he's a wannabe software developer.
Mm-hmm.
And I'm telling him, help me with the due diligence. And of course, being the annoying guy that he is, he's looking over my shoulder and he's saying, this is ludicrous the way you're doing this. We're on a flat fee basis. I've never seen something more inefficient than the way you're handling the data. So that became the genesis of, let me go see what's out there to make this a simpler, more efficient process. So we started working with Smartsheet. It didn't have all the functionality, and we settled on Airtable. You know Airtable. It's a collaborative, basically spreadsheet platform, and what we started building was a platform to essentially chaperone the seller data. So we're organizing it into the logical silos that correspond to the due diligence request. The due diligence requests are a lot like interrogatories now. There's like 500 of the questions. So we pull all the questions down onto Airtable, and I'm happy to show you one day if you want to take a look at the old legacy platform.
Mm-hmm.
And we organize it within the proper silos. We parse the data, we tag the data, we identify the data so that it flows at each step of the deal. And so if it's HR related, it's going to go to the HR request for due diligence. It's going to go to the HR rep. It's going to go to the HR disclosure schedule. So you don't have to keep going back to the same data over and over at each step of the deal.
Right.
Airtable, it's a purely collaborative platform, so everybody can talk to each other and say, what's this, what's that, I need to see this, what is this document. It becomes a data room on steroids. But then over the years we continued to add functionality to it. So we started extracting intelligence from the data using Microsoft Power Automate and other tools, combined with HI, which Letty calls human intelligence, which are non-lawyers. They're very bright people that we don't pay all that much to. A lot of them have MBAs. They're sitting at home with kids, and they're good with documents, and we teach them what we're looking for: change of control. We're looking for insurance, assignment, indemnity. We tee it all up on the technology platform. And of course, now with our adventure with Codex, we're starting and with AI, we're starting to introduce AI to sort those documents and pull, still using HI and ultimately using attorneys to backstop everything. So that platform wind up being called Deal Driver. It's a utility. It's the classic consulting firm builds a utility to help them be more efficient. But the utility winds up being more interesting than the consulting practice, and over time, particularly the private equity funds, they started saying, hey, can it do this? Can it do that? And obviously there's limitations on Airtable for privacy, for one thing. It's not possible to create different teams that have only access to their window, and it doesn't synchronize very well with Word. And for most lawyers, if you look at a Airtable platform, it's a big giant spreadsheet. It scares them to death. There's no charts, there's no colors, there's no pretty pictures, there's no Wall Street Journal subscription, there's no API to Relativity or whatever that they use to search their documents.
Mm-hmm.
So that, of course, eventually, and it's not in its legacy form, it's not a platform that we can hand off to anybody, because it's really a Frankenstein monster of all these different applications that Lenny behind the scenes and his team is handling like a marionette master. So finally, after all these years, we went out and raised some money from mostly our clients and ourselves, and we're actually properly porting that platform to a platform that we own. that we can now make available in a commercial way, which, where we go with it, I don't know. We talked about that in the other podcast, but we do have a deal driver entity, which is, and of course, the deal driver experience is what stimulated the Codex thing in Stanford, because they're saying, oh, look at these cool things that Flatiron is doing. They got technology and they got flat fees, and why not, are you interested in doing this? And that created that whole tranche. So now we have this portfolio of assets that I don't.
But you're using it too. You're using Deal
Yeah.
Driver, your version of it, or you're.
Oh yeah,
Yeah.
well, that's the beauty of Flatiron, right? Flatiron is actually a laboratory. It's a testing site. It's a laboratory. It's an evangelist. It's an early adopter for Deal Driver. So we have 25 deals under our belt. We have a lot of users that will say nice things about it. Now, listen, honestly, some big law firms didn't like it. I want to use my spreadsheet. I want to use Word.
Well,
but
they're also thinking in the back of their head, this is going to introduce too many efficiencies into my practice, and it's going to hurt my bottom line.
Maybe.
You should look down market for Deal Driver. I'm just saying, there's,
Oh no, I agree.
Yeah.
No, I agree with you 100%. I think there's, for Deal Driver itself, there are two plays. There's the kind of the Salesforce play where you install it at a big law firm and they put in their own content, and there's a whole support consulting group. Then there is a subscription SaaS for the AmLaw 300 thing to do small deals with prepackaged content, SaaS purely subscription, and they can use it to do small deals, and you don't need all the bells and whistles. I think is a much more, actually a very attractive play.
Have you heard of the website acquire.com? It used to be MicroAcquire.
Yes. Yeah.
Yeah. I mean, like integrating with a platform like that, like there's something there.
Or LegalZoom, or one of the legal publishers, so coming back to the fixed fee then. So that's the way we do it. We have, structural level efficiency at the firm level, the way we run the firm and the expenses that we have. We have a general contractor labor model, which allows us to be a lot more efficient than having all that labor and training. Now you're going to tell me at a certain point, the big firms are going to smarten up and they're not going to give you access to all this trained labor. Well, by the time that happens, I mean, 20 years from now,
I don't think that's going to happen, because there are companies banking on that still being a thing where they have flex talent. None of the names of the businesses come to mind, but Alex now works for
Axiom and Bliss, and and then the LSAPs, they use basically legal talent as well.
Law Trades,
United
Latitude,
Lex, and
there's a lot of these, right? So I mean, and even down, the down market version of it is Law Clerk. If you've come across,
exactly,
yeah. So
we actually use paralegals from Law Clerk, so we outsource it.
When I went solo, I signed up for Law Clerk to do, contract work as I was building up my book of business. I mean, I'm not on there anymore, but yeah,
I don't need to do, all I got to do is go to LinkedIn right now, because there's so many of these kids have been detached, and look, a lot of these, I call them kids, but they're adults, but a lot of them, have left for good reason. They don't want to do 3,000 hours, and they want to have a family, but they still want to practice. So that's our ideal profile, and we have no trouble. And we've had a very loyal base of attorneys that they're always available to us. So the three prongs is the overhead, the way we deploy labor, and the way we apply technology. Those three things combined allow us to price ourselves on a fixed fee basis. It's still not particularly scientific like you do, where I'm basically riffing off BigLaw, because there's so much. They put 20 bodies there, and they'll charge $750,000 in a $10 million M&A. So even if I get a quarter of that, the third of that, under my model, it's great.
Yeah, but you said something earlier that kind of applies to me, though it might not be exactly the same application, and that is that I will have clients where I'm their fractional GC, But when they're doing an M&A deal, they still hire the biggest law firm,
Yeah.
regardless of the cost, because they want the other side to see they've hired the biggest law firm to like put pressure on them in the deal. Like that's the only, they'll pay whatever.
Well, look,
So,
we have to deal, we have to deal. That's why I talk to you and others, and we're very active on social media. There is a community of clients out there that are genuinely interested in change. And
yeah,
listen, we've established a reputation now. We're not out of the box anymore. We've done a lot of deals. We're Flatiron. We have good talent, and the big firms know us. So there's credibility to be played here as well. But you're right. I mean, it's always a challenge, with like I said on the other podcast, big firms are out there trumpeting all the innovation that they're doing and all the technology that they're adopting, but their rates keep going up.
right,
So
right.
I don't know where all that innovation is going. It's not being shared with the client community. And the funniest thing is when they say, well, we have to increase our rates because we have to invest in technology. So you're telling me you have to increase your rates to be more efficient. And so it's,
Yeah,
but look,
the hypocrisy there is a little palpable, and I've been giving CLEs now for years on the subscription model and all that. But when Gen AI hit the scene and we started to see the efficiencies right away in substantive legal work, let alone the non-billable stuff. Like if non-billable stuff, BigLaw will adopt Gen AI all day, and I think they're going to start to
oh
see
yeah, for non-legal, yeah, because they're going to, there's,
right.
look, there's going to be, I have told this to others, some big law firm, probably a magic circle firm, because they have different pressures outside the US. They compete with, a broader community of legal providers, is going to do some sort of an off-brand thing where they're going to adopt their discount brand or some other off brand. They're gonna start experimenting with different models so they can be more competitive. I do the obviousness of being able to price yourself more efficiently and preserving your margin, and then being able to deploy that labor on other work, is the obviousness of that. As counterintuitive as it might be to big law, is going to strike somebody. I know it's going to strike somebody, and
And there will be an ethical tipping point. Now a CLE I used to give on Gen AI creating too many efficiencies, so you got to come up with a different business model. It's actually for the first time I've been asked to give it in the context of a legal ethics presentation.
oh, that's interesting.
Because at some point you're going to need a 50x your rate to make up the difference, and at that point it's probably an unethical fee. And
It's not,
and
and that's not the answer. The answer is to redeploy that labor and do other deals with it,
right.
and reduce your price. So you're still going to have your margins because of the efficiency, and you may not need as many bodies, and you may not need to wreck people's private lives. Like my private life was wrecked 30 years ago when I was going through the mill. Nobody went through it harder than I did in the 90s and early 2000s. And
Yeah.
it's not a bad place to go.
Yeah, and
But
there is one firm, I don't know if you're following them, but it's a larger firm, Hush Blackwell. I mean,
yeah,
they
I've
have,
heard that their employment or
I can't remember exactly which practice areas they're in, but I will tell you they were one of the first ones to do like a virtual office that they've now expanded, and I think it was effective this year. They stopped billing time.
okay, well, I'll tell you, and I know they're doing something. I thought they were specialized, and the specialized practices like estate, and of course, class action is already commoditized.
Right.
Um, Look, the other interesting thing is the sandboxes. I mean, we flirted with the sandboxes. We were actually actively discouraged from going into the sandbox because basically the bar wasn't ready for us. The bar is ready for social justice out of the sandbox. So
Right.
if you're providing access for indigent people to the legal services, then they're okay with using non-lawyers and using capital backed. But when you want to compete against their bar members for their bread and butter, they're not so enthusiastic. But that's not going away, Matt. The idea that you can attract third-party capital, investor capital to invest into technology and bring in, non-lawyers to perform some tasks and combine it into, with a different model, like an E&Y kind of model. That it's really interesting. It's just not right. But, the ball's been pushed a little bit down the.
Yeah. I mean, we covered a lot. As we start to wrap up here, I'm curious to know, since I think you've got this covered though, because you said you work with contractors all over the place. Inherent to what you do is multi-jurisdictional. So like, how do you handle? Is that how you handle it? You just find a licensed attorney in that jurisdiction, or what's your approach to something like that?
Well,
No legal ethics advice given on this podcast. Everything's
yeah,
for educational purposes only.
we're a New York law firm, so New York is more or less the corporate law of the U.S. So
Right.
you have this implied license when you're practicing corporate law that you can do M&A. It wouldn't be the same if I was sitting in the sandbox in Utah, and that's one of the reasons we didn't go to the sandbox. I wouldn't have that implied, that implied license to practice corporate law anywhere. It's sort of like Delaware. So that's one thing. Two, we have a very heavy practice that's East Coast to West Coast. So we have coverage in California. We have to. We have lawyers in California. We have lawyers in New York and in New Jersey and in Massachusetts. So the big M&A places, we have boots on the ground. And then beyond those areas, we like every other law firm that doesn't have an office everywhere, but it's based in New York. We practice corporate law under our New York license. New York license is worth a lot.
Yeah, yeah. It's amazing to see what you're doing. There are to my knowledge, you're the only like dedicated to alternative fee-based law firm that is competing against BigLaw. I mean, you are and you aren't for reasons you described, but so many of the guests on my pod and a lot of the alternative fee-based smaller law firms are just serving unserved markets or going after that blue ocean.
Yeah.
You're staying in the red ocean, and one of the reasons we'll never be able to compete with BigLaw is because the value of having an attorney license in every jurisdiction is something that it's hard for small law firms to get around.
Well, look, we're limited in the offerings that we offer. We offer M&A and corporate, and we don't do litigation, and we're not doing specialty work. We have coverage in the important jurisdictions.
Right.
And so, it's and we're leveraging technology and a different labor model to make ourselves bigger than we are. And we're able to achieve that.
Right.
Look, I was at VLP, and I know the folks at Ryman and Fisher Broyles. That's an interesting model, but it's a different model. I almost call them a seat license model. I mean, if you have the qualifications to practice law, at a big firm level, you can, no matter what your practice is, you can go to the LP and pay the manager. You can pay the firm a seat license for the practice platform, and you're going to have the ability to have some synergies with other lawyers at the firm.
Right.
But it's a light marketing model. It's a light branding model, and the owners of the firm make some money off the VIG. Nothing wrong with that model. I was under, but that's not what we want to do big law work against big law, just and using a different methodology so we can be more efficient. And it was meant to be disruptive. We wanted to be disruptive. We are disruptive. Now, the other thing, Matt, it's not what we found, again, this whole thing with the deal driver, the accidental utility that became, sort of our calling card. The other accident of deal driver was that we found that particularly the private equity and the buy side, they think the deals are better because we're producing better data. We scrub the data and we sort the data and we parse the data. So it all flows into their little silos. So they have 50 different acquisitions. It all flows. So that's why we always say, deal driver and Flatiron, better deals, better outcomes, because it's not just pricing. So that's been another competitive advantage that's come out of this process that, again, somewhat accidental. We can price ourselves more cheaply, but in some ways, we're also producing cleaner deals.
And it's better value.
Yes,
Even
exactly.
you could probably charge a lot more and still the client's getting an incredible value for what they're getting. And when you stop billing your time and you stop thinking time equals money and you start being efficient and output or results equals money equals value, then that's what happens. You said it was a little bit of an accident, but those are the types of things that happen. I have one more substantive question for you and then a fun one as we wrap this up, Conrad. And you could feel free to keep going on what you were just talking about in answer to this question, but it is, of the guests I have on my show, there's usually there's a reason why they are a disruptor. And so what is it about you? Because you said it was decades ago you saw the inefficiencies, you knew there had to be a better way. What do you think that it is about you that allowed you to see through the BS?
I think I'm an entrepreneur who got stuck in big law. So and Lenny is the same. I think about it a lot because it was disruptive to my private life, needless to say, and it was disruptive. I could have just been one of those Jones Day lifers that are now being pushed out the door because they're in their early 60s and they're not. They've done fine, and their retirement. But unless you're a big business generator, when you reach 62, 63, it's the sequence is over. I could have done that, and I think all the time, why couldn't you do that? Because I was all from the moment I was in there, I was thinking we can do this better. There's an opportunity here. There's a business opportunity, and it was those convergence of factors, including the fact that I was kind of a refugee at that point after I'd left BigLaw. But the convergence of factors, the access to labor and the access to technology, and that all converged. I wish I had converged 10 years earlier, but so I always was itching. And my ex-wife would say, why didn't you stick it out and attach yourself to a silo at Jones Day, and you could have, but I was always itching to do something else.
Yeah, the entrepreneur brain and that itch is a common through line for guests on the podcast, without a doubt. The last question for you, Conrad, is just a fun one, and that is a hot dog a sandwich, and why?
Is a hot dog a sandwich, and why? I consider it a sandwich because it comes on bread, but that's very unscientific. That I would put it in that category. Yeah, but it could be viewed, I guess, as a snack. But no, but I'm also from an older generation. We ate more hot dogs when I was a kid.
And it was still, I couldn't tell you what's in a hot dog today, and you probably definitely couldn't tell you what's in a hot dog back then. Well, Conrad...
I worked at Nathan's. That was one of my first jobs, believe it or not. Yeah, at the Livingston Mall in New Jersey.
Yeah, so you may be a hot dog expert then, Conrad.
I don't know if I would. I don't put myself in that category.
So we'll have you stick around after we sign off, but just if folks wanted to get in touch with you, what's the best way for them to find out about your firm or reach out?
Well, go to the website. By the time this post, we probably have a new website up. That's flatiron.legal, not. And you can reach me at my email, my name is Conrad Everhart. So Everhard@flatiron.legal. You can reach me there. And you can also if you go to the website or the LinkedIn, you can reach me there. There's my contact information.
All right, great. Well, like I said, we'll sign off. So stick around just for a minute here, and we'll say goodbye. So one more time, Conrad, thanks so much for coming on the show.
Yeah, appreciate it. It was a lot of fun.
And that's a wrap. Thanks for tuning in. Make someone's day by sharing this episode with them. The best way to get in touch is to follow and message me on LinkedIn. To get extra content, subscribe to the newsletter at www.lawsubscribe.com, where you can also become a paid subscriber to get episodes and content early. Until next time, this is Matthew Kurbis with Law Subscribed.